Last but not least, in any way, in your opinion, you know, the emails that I've got crowded my inbox and several other members, are we setting precedents, Representative Ballinger, for any form of discrimination or future lawsuits that could really cause for some unwarranted days ahead? From your legal perspective, in your opinion, do you feel that we're going down or creating a slippery slope that could cause some things here that I know other states have either fought legislation similar to this, or we don't killed the bill, for lack of a better term, or amended it in a way that made it watered down? What do you foresee the future of this bill doing, and do you think that in any way is this creating a new form of discrimination?
Okay, the answer to your last question is no. One thing we're not doing is we are not in a position where
hold on. I would appreciate it if the public would keep their comments and outbursts to themselves. We're trying to take up a very serious matter, and we've accommodated a large number of people in this committee room today, and I would appreciate that we respect the decorum of the House moving forward.
The situation is that we're not creating a new experiment here. What we're doing is stepping into to be consistent with 31 other states that already use the strict scrutiny standard. We are becoming consistent with the federal government that already has and uses the strict scrutiny standard. The reality is we're in a minority of states that doesn't have a heightened scrutiny for the protection of religious. I think the best example I have of recently where a RFRA would really have made a difference. Most of the time the RFRA is not applied. Most of the time when the RFRA is applied, the state wins. There's a mountain of case law out there that deals with religious practices. A small part of that deals with RFRAs. The vast majority of the case where the RFRA was brought up, it was actually an individual who's incarcerated, and this bill actually exempts them. And even in those, most of the time the state wins. Now, one situation recently where RFRA would have happened and would have helped is a lady named Mary in Kansas who was a Jehovah's Witness. Jehovah's Witnesses have a deeply held religious belief that they don't take blood transfusions. She had liver disease and she needed a liver transplant. Kansas had a law that said, you know, if you're going to get a surgery with Medicaid in Kansas, you're going to have the surgery done in Kansas. Generally applied to everybody. It wasn't pointed at any particular religion. The problem is she doesn't take blood transfusions, so she needed a bloodless liver transplant. It's actually cheaper, the liver transplant was, but they don't do them in Kansas, they did them in Nebraska. The law specifically prohibited her from being able to get that liver transplant in Nebraska. There was actually an exemption in the law for emergency situations, but what they said was religion doesn't amount to it. The circuit court said, sorry, law is constitutional, there's no religious exemptions. She appealed it, and eventually Kansas actually read in a strict scrutiny standard to get to that point, and she was able to get, you know, she was allowed to have that liver transplant, but it was too late and she died. And the reality is that when we look at people's religious protections, we should have to before a state makes a decision, we should have to take those into consideration. I think that's why it was included in the First Amendment. I think that it was a shame when we dropped that standard to something that's less than what it was. But honestly, that's where this bill applies. Individuals have used this as kind of a symbol of something that they want to attack, and I understand that. There are a lot of people who are hurting, a lot of people who are frustrated, a lot of people who are doing a lot of things. But the reality is we're concurring in some Senate amendments that I've agreed to on the Senate side. We're just concurring in those amendments. We've had debate on this bill. You know, from my standpoint, I think that this is probably something that, you know, we've had the opportunity to make whatever changes that need to be made, and they were made. And now we're back here just concurring in those amendments that were made.